Good morning, everyone, and thank you very much for this introduction. I would have liked to continue listening to you instead of taking the stage and trying to bring some considerations about democracy in peril to you. When I was invited generously to participate in this event, I felt challenged to think about Arendt, and not only about my court rulings and my files and courts and institutions and all that. And I proposed to talk about the practice of doing justice in courts, because I thought Arendt is about action. So that's what I'm trying to do. And I wanted to pose questions to you because I want to win you over to become friends of courts, which maybe you are already, and then that's fine. But my experience is that many particularly critical and smart scholars are not. And that's why I put an effort into making you amici curiae, friends of courts. In your program, this keynote carries, however, the title Democracy in Peril. And what I want to do is to call on you to help save and strengthen and live an ever better democracy by becoming a friend of constitutional courts in particular. This is why my focus is on constitutional law, broadly understood as both national and international rules that govern democracy or government in general. So if I say constitutional law, it's not the nation state only. It's transnational, international, all kinds of legal regimes governed by a specific concept, and I'm going to get to that. And certainly I will do so with Hannah Arendt. I thought that's the call of the day. And yet the argument is certainly also based on my understandings of law of what has been called a radical feminist perspective, as well as on my experience and indeed the practice as a sitting justice in the Federal Constitutional Court of Germany, brief Karlsruhe. And this is certainly an entirely biased presentation. But who is without bias on anything? So I'll try. The starting question then is, are you a friend of a court? Of courts, an amicus curiae? If not, you should better become one, and you should do so quickly. In times of populist politics, and in times when formerly mainstream party politics are driven by and towards populism, the importance of law in our society is scarily obvious. Law is needed when democracy is at risk. This is why we need, I think, desperately, friends of courts, amici curiae. However, many very smart people and extremely critical people are genuinely, for some reasons, not. Is it Hannah Arendt? She had a rather ambivalent attitude towards the law, with her key focus on politics as collective action. So there might be a temptation to go for the political activism side and kind of dismiss, disregard, or not take law seriously enough. What is known is that she was very skeptical regarding human rights in particular. Yes, she was a fan of US constitutionalism with its emphasis on federalism, however, and liked the US Supreme Court to a degree, but did not identify courts as what she calls the counterpowers needed to guarantee that rights are indeed rights, not fantasies. Arendt was in favor also of an international criminal court for crimes against humanities, but generally somewhat missed the point of constitutionalism, with courts as the key institution empowered to turn human rights into realities. So with Arendt, you to a degree must be a skeptic when it comes to human rights and law and courts. But I suggest that with Arendt as well, and without, in addition, you may also understand law as a productive force embedded in the world, always connected to, but not synonymous with, society, politics, a collective practice. It seems to be the spirit of this conference, the concept of this summit, that says, lawyers, I quote from your ideas, lawyers are crucial power brokers, agents of change, and can act to emancipate, to empower, and to amplify concerns otherwise suppressed or ignored. And this conference, indeed, wants to formulate a response to the need of a new phase of critical and forward-looking engagement with a changing world. I assume this includes the law, and this includes the courts on your side. And this is what I will call critical lawyering. It's, however, an affirmative stance taken towards the law, and with my remarks, I thus want to contribute to the very effort of this whole conference. So let me try to win you over to become friends of the courts. First, I want to address the attitudes among scholars, academics, lawyers, politicians, and activists towards law. Many are either conservative, and I certainly want to challenge that stance in light of their critique of constitutional jurisprudence. Others, and many who identify as left or radical in the academy, are nihilists when it comes to law, and I intend to challenge that stance as well. And thus I propose to invest in a critical attitude, yet a pragmatist one, to meet the challenges of the day, democracy in peril. However, to engage the law critically, and this is my second point, or will be my second point, it must be based on a thorough understanding of law as such and courts in particular. With Arendt, law may be understood as a collective practice. With Arendt, we may acknowledge the role of law in our societies as more than simply oppressive. She got that point. Law is always also procedural, and it's productive, more directive than imperative. But most importantly these days, and this is going to be my emphasis, there is no law that deserves the name without courts as its institutional backup. Third, then, this forces us to revisit what is often sloppily called judicial activism or the gouvernement de juge, that scary thing out there. Instead, I propose, based on a closer look at courts and at judging as a practice, one may conceptualize critical pragmatist lawyering to counter the risks to democracy because democracy is in peril. So the attitudes. What is your attitude now really towards the law? In the academy and among lawyers, be they advocates or judges or politicians or administrators, generally speaking, I think there are three attitudes which are widespread, and I named them. Interestingly, these three attitudes, or the variety of attitudes toward the law as a starting point, are an important element of diversity in judicial bodies. On the bench, you find these attitudes as well. People who like it, who dislike it, who disregard it, who trust it, etc., etc., etc. The bench in a court simply mirrors the world out there. It's not that different. You find these three attitudes all over them. In our times, with democracy under attack, with populism ruining the rule of law, some of these attitudes are, however, much more problematic than before, and a productive stance is thus desperately needed. So first, there's the attitude to defend the status quo. These are the people who genuinely like the law. They like the rule of law, they like democracy, and eventually, yes, they like human rights. They are conservative in the true sense of the word. They are also positivists. They're etatistic thinkers defending the nation state, not necessarily nationalistic. They get that citizenship gives you the right to have rights. Sometimes they're a bit naive, but as legalists and status quo conservatives, they defend the rule of law in situations even when it's obviously used for problematic causes. So they're formalist believers in the law. This is particularly obvious in international law, and I think critical studies in internationally expose that point again and again and again, that law there is an interesting, nice, democracy-sounding means, but in fact often used for colonial interests. So the status quo conservatives would still defend that because after all it's law, isn't it? But I think that is a rather problematic stance. And as Anna pointed out in the beginning, feminist jurisprudence for a long time has exposed that formal equality, a formal belief in the equality guarantee, is the velvet glove on the fist of domination, as Catherine McKinnon has called it, the velvet glove on the fist of domination, which is why a formal legalistic defense of law, a status quo defense of law, is not doing it. Instead, it's undoing the promise of the rule of law. So what about this attitude in times of democracy under attack? Many good conservatives defend the law and the rule of law and constitutionalism. But interestingly, the seriously conservative defenders of law that protects the status quo, thus mainstream interests, thus dominant interests in society, and even more those defenders of law that covers up their own interests, do not like constitutional courts. That, I think, is interesting. There are clear reasons why. And Arendt, in her description of denaturalization laws, saw that. In her analysis of totalitarianism, she noted that nationalism took the law not brute force, not money, took the law to denaturalize and thus naturalize the nation, to ethnicize, to racialize the nation state. It was not brute force or money. It was the law itself that was abused in those fascist dictatorships to get what they thought needed to be done. Law is thus a powerful means, and that there is no guarantee, and there's no guarantee per se that it will not be abused. So a purely formalist belief in legalism is not doing it. In Arendt's description then of the American Revolution, she focused on federalism to keep powers at bay, and she emphasized the civil society to produce a recognition of rights of reciprocal respect. But in today's constitutionalism, I think this is all fine, civil society, wonderful, but it is courts that are needed to limit the power of the use of law, and it is courts that are designed to intervene when law is abused as a means to reach illegitimate aims. Constitutionalism as such is the idea to bind rulers to the rules and eventually have courts enforce that. It applies to nation states as well as to transnational and international entities. So again, a large notion of constitutionalism. And the central idea is there is no rule by any law. So if it's the form or mode of law, it does not do, but rule by law bound to the rules of democracy and to the respect for fundamental rights. And this needs a separation of powers, and namely, it needs independent courts with a constitutional mandate to be kept at bay. So if courts are truly independent, and if courts have the mandate and the courage, in addition, to not in dubio simply perpetuate the status quo, they are a problem for conservatives because they like the status quo. They profit from it. This is why conservative defenders of the rule of law do not like courts too much. They like the form of the law and the power of the law, but not those courts who intervene into the legal game based on more foundational rules. Specifically, constitutional courts become a problem when they stop an elected majority, structurally always conservative. This happens when a court strikes down laws against terrorism carried by a majority's feeling of fear and insecurity, yet violating fundamental rights. Courts also do stop majorities to the dislike of conservatives when they stop a plane from taking off to carry refugees back home to their country, either because the country cannot guarantee the right to have fundamental rights, a totally Arendtian point, or because the regular court that sent the person off did not adhere to regular standards of the rule of law. This is an intervention then in a drive towards exclusion, in a drive to protect us, the real nation, and the courts then demand substance rather than just form, and status quo conservatives, certainly a little bit, roughly sketched out here, status quo conservatives do not like that. Even more so, courts become a problem for status quo conservatives when courts take the basic rules to call for a change of the status quo actively. This happens in rulings that take the social dimension of fundamental rights seriously. Then it gets really, really uncomfortable. So if constitutional rights dare to break that seemingly liberal super consensus that rights are only directed against state action, thus negative liberties, etc., and understand that there's always a social dimension to every liberty out there, the status quo conservatives are not amused. They insist that social rights are a problem or do not exist at all, and that fundamental rights should be reduced to protection against state action. So when courts, and certainly I do take these examples from Karlsruhe jurisprudence, but I could have picked on many, many other jurisprudences out there from courts. So when courts mandate a state to pay a minimum amount of welfare to refugees, or when courts and say that the right to dignity is actually to be taken seriously, and when courts understand dignity as a minimum guarantee of dignified life for all human beings on the territory, status quo conservatives do not like it. Then courts are criticized as going too far, managing society instead of speaking the law only. Also, when courts mandate access to health care, or even worse, access to reproductive freedom, status quo conservatives do not like it. And certainly, if courts strike down exclusive legal options to live one's private life, as did heteronormative family law, or exclusively heterosexual marriage law, status quo conservatives are really not amused. In light of these examples, and with what you may call a bias, feminist and judge, a double bias, I do not consider status quo conservatism thus a feasible option. And in light of recent attacks on constitutional courts in particular, by which I always mean any court with a constitutional mandate, thus constitutional courts, tribunals in Hungary, Poland, Turkey, as well as another example, the International Criminal Court, the Strasbourg Court, or the ECJ, all courts with constitutional mandates, they're all included in my list. If you take the attacks on these institutions seriously, a status quo conservatism that criticizes a court when it intervenes to stop majoritarian or even populist politics is really dangerous. That critique is misguided and a dangerous critique in these times. So let's look at the alternative, the opposite attitude. And I think at a conference like this, it is much more likely that you do meet a defender. It's not very likely that you do meet a legalist defender of the rule of law and a status quo conservative. I don't know why I got this impression, but somehow. Instead, at least for a long time, it was much more sexy to drop a rather dismissive, sometimes snotty, sometimes totally malinformed, but really totally critical, the law or the courts or those judges. This is the other side. If conservatives defend the law at a cost, my argument is that these nihilists, as I want to call them, reject the law at a cost as well. They are so afraid of what Carol Smart so brilliantly described as the siren call of law that they never set sail and never enter these waters. Politically, this is a pretty lefty attitude for those who understand the law as just another means of power of the system, another instance of authority, if not authoritarianism, and a mechanism of closure, whatever field you're working in at the moment, all to be rejected. Some do claim Habermas for this and still defend a private against law's invasion into the Lebenswelt. Those nihilists reject the law as encroaching on what they consider freedom. However, read Habermas, all the way, he got it that and acknowledged the law as a productive force to allow for democratic decision-making. And generations of feminists, as Anna Lutfi exposed in the beginning, generations of feminists have exposed the flaws of such understandings of the life world and a private realm that is only free for some to dominate others. Therefore, I think that version of nihilism really does not convince me. Others, in versions of what is called postmodern critiques of law, are afraid that law silences all others. There's a fear of legalism, of the juridical, of the totalitarian nature of law, of that limited code of right and wrong only that never captures the full humanity in all of us, etc., etc. Specifically, there's a widespread criticism of juridification, not just the juridical, but juridification, so related to courts. Some claim Foucault for this, who indeed exposes problematic and subtle effects of law, and some deconstructivists denounce the law as only covering the violence in a specific form, yet I think may not have fully read Derrida. Certainly, law carries violence, but this does not inform nihilism towards the law. But it informs, in Derrida's work, a call for ethics in judging, and that's an affirmative stance towards the law. More importantly, nihilists do not offer an alternative to stop violence, even if it is embodied in the means of law as well, eventually. Some others, and they could use Arendt to a degree, want to save the political from legalization. Not the private, but the political. That other sphere of activism and great things happening. Some see law as an inherently authoritarian, per se silencing mode then. And certainly any use of law, any concept of law, and any ruling must be criticized if it silences others. But if it does silence others, and it does not naturally and per se and not totally do that, These critiques of law both overstate the power of law, which is not able to ever totally silence everything else, and it underestimates the potential of law to intervene when all else fails. Law does never fully replace politics or any form of civil interaction. Law is not that strong, but it is strong and not to be entirely disregarded. It intervenes. It also stops things. It does not replace politics, however. So when it comes to sexual violence, including pornography or prostitution, a refusal to accept the option of law to address such injustice leaves the women who want to survive at a loss. So that nihilism comes at a price as well. Similarly, critical race theory and post-colonial analysis of law is extremely important, and I cannot more than emphasize that point again and again and again, extremely important to expose the abuses in the name of law and to expose good governance policies that violate the law and fight for human rights. New realists in international law thus note that, I quote, "the International Human Rights Project everywhere seems in retreat," and we need to criticize that. Many observe that in light of torture and genocide, corruption and shady dictatorship, an outright failure of human rights is what we see. But then don't draw the nihilist conclusion. That conclusion would echo Burke, and it would echo thus Arendt, who picked up Burke, in their critique of human rights as merely romantic illusion. Because human rights are not implemented, they forget about it, or tell us to forget about it. But that is, I think, not a proper stance. Watching the Eichmann trial, then, Arendt even came to propose an international criminal court. So, looking at the real atrocities, even Arendt, with all her skepticism towards the law and human rights and disbelieving in the human rights promise, etc., then came to call for that kind of institution. So if we do not want to retreat to brute force or social Darwinism, there is, I think, no feasible alternative. Yes, biased, but who is without? Therefore, nihilism does not convince me. Finally, just to mention that alternative as well, some nihilists do praise action instead of that boring exercise of judging or applying the law or, lawyering. They may also claim some Arendt because her constant call for the need of constitution making was a call for a utopian vision of permanent politics. That's how she described constitutional jurisprudence. But they miss Arendt's point that judging is part of all meaningful action. So that boring exercise is part of what she would praise as politics. And all else is some amazing idea of activity. So they miss the political realism in Arendt's call. So when those who favor action and activism emphasize civil society as the only promising locus of inclusive democracy, I think they miss that the law is a frame and allows for and protects civil society. If we look at the quick erosion of rights to academic freedom, rights to free speech, rights to the media, rights to association, and if we take this seriously, and not just as some political discussion out there, but take this seriously, that there are really things taken away from people, a stance that rejects these rights and emphasizes that civil society should be taking care of this, while civil society is crushed at the very same moment, I think is naive or utterly dangerous. And note that Arendt herself named one fundamental difference between totalitarian and all other concepts of law: the difference between law and lawlessness. And so to call for lawlessness, because that other version of political activity is so much more attractive, is a dangerous stance. According to Arendt, totalitarians promote a defiance of all, even its own positive laws, implies that it believes it can do without any consensus, juris, whatever. So in times when we see populism with totalitarian tendencies to defy all, specifically positive laws protecting democracy and human rights, we need to work, I think, on the consensus juris. So the third attitude, the consensus juris. I call it critical pragmatism to inform critical lawyering. Maybe it is the combination of a radical critical academic and constitutional court practice. I, yes, admit that. But, there are many versions of this. And you may also use Arendt, because her thoughts were scattered on the law, to develop such a stance. Most important, however, facing autocratic legalism and attacks on constitutionalism all over, I think such a stance is really needed. And to be sure, it is a critical stance and not the version of, simple belief in the law is a good idea. That's not what I'm calling for. So Arendt observed that the risk of a non-critical stance, of legalese, is the risk of distancing from empathy and distancing yourself from humanity in our shared existence. She called it officialese. That was the language of Eichmann, officialese. And Eichmann called this his only language, which is, according to Arendt, the most reliable of all safeguards against the words and the presence of others, and hence against reality as such. So again, I want to be critical of too much legalese, of too much abstraction, of a formalist belief in the law. That's not my point. But nonetheless, I think we need an affirmative stance. The point of a critical, pragmatist, affirmative stance towards the law, critical yet constructive, is sometimes called a constitutive model, and many have engaged in such work. Saving human rights as law from the mix of rhetorical decorum and practical fatigue. You may choose your emphasis. You may pick ideas here from critical legal studies, from feminist and queer jurisprudence, from critical race, post- or anti-colonial legal theory. But the point is to defend the law, not per se, not in any version, and not to reject it altogether, not become a nihilist, but to critically engage it. So to do so, you need to find your interpretation of Audre Lorde's famous saying that the master's tool will never dismantle the master's house. To me, this is always an important warning, not to ever underestimate the subtle powers around me and to watch out for the negative effects of law. So do not be trapped by legalese or officialese. Do not fall for the formal qualities of the law only. Confront the law. And if you see law as the white male capitalist master's tool, you must confront it. But if you look at courts that intervene into what the masters desire, to stay in that picture, and if you look at law mobilized to address the needs of people the master exploits or ignores, you must reconsider a nihilist stance. And you must affirmatively maybe support that. So we need to distinguish. Yes, there is law as the master's tool, as unjust law, mere technical form and mode, unchecked, unlimited, law without the rule of law, law without constitutionalism, without independent courts. And to dismantle that master's house, such law will not do. But there's also law under the condition of constitutionalism, and only then it is a tool to challenge, to limit, to hold a master accountable. Then law is able to effectively address social inequality, safeguard democracy, and fundamental rights. And you may find Arendt here interesting as well. Her emphasis was on the polis, on collective action, so we need to understand law as a practice to be taken up in collective action. Namely, to allow for and to defend democracy, we need to properly understand and conceptualize constitutional law and constitutionalism. And if constitutional law deserves its name, we need to be critical pragmatists when it comes to court. So I suggest to understand law not as power or theory or closure or that other problematic thing or doctrine only, but as practice. So it is important to understand the productive force of that law. It is important to understand that it's a collective enterprise, and it's important to understand the role of courts in that. The productive stance of law is opposed to the vision of law in the penal paradigm, which sees law as only oppressive, repressive, prohibitive, sanctioning the bad idea. Rather, and again with Arendt and with Foucault and with the rich work in socio-legal studies, we can acknowledge the role of law in our societies as productive. Law is doctrine, law is institutionalized force, yes, but law is also always procedural, productive, more directive than imperative. And I quote Kim Shapley here with her excellent analysis of what can be abuses of law, but what also should be upheld as constitutionalism. She says, legal doctrine is like a rough draft of social theory comprising concepts, categories, rules, and procedures for managing the vast array of human conduct. And this management is not for others, it's for all of us, it's also for you. Thus, law is not just politics by another means or another name, and it's also not entirely apart from politics, but it's co-producing politics. It frames politics, it allows for politics, and it also safeguards politics. And there are many, many, many court rulings to illustrate the point. Famously, free speech and uncensored media, including rights of access to speech and media, or court rulings on freedom of association or freedom of assembly as political rights, all produce democracy and civil society and are not opposed to it. When courts protect these, they protect democracy. And they do so, example from Germany, and they do so when they protect G20 protesters. You might have observed the quite violent protests in Hamburg the other year. So when courts protect the G20 protesters from being put into a camp far away from the city, which the police suggested, the idea is that as independent institutions, they stop majorities from being bothered. I think that's an excellent idea. And that's where you need courts, because there's no one else to do that, by the way. But also, courts do protect democracies when they force municipalities to open their facilities to far-right political association. That's the very same move. And this only, however, works if people accept that courts do that, and if the court then has amici curiae, friends to support it. Remember that these are not the conservatives nor the nihilists who would then come to the side of these courts. My point is that we live in times where we need the critical pragmatist friends of courts. So let me illustrate that. A few days ago, actually I think 8 days ago, Karlsruhe, my court, Karlsruhe, ordered the town of Wetzlar, which is a small municipality somewhere in Germany, to open their city hall to the right-wing nationalist party, the NPD, a racist and anti-Semitic political party that was, however, not prohibited in proper proceedings by that very same court. So they wanted to have access to the city hall, and the municipality in the fight for democracy and standing courageous citizens, etc., stood up and said, no access to the city hall. And they were celebrated all over. However, the town was taken to court, and the court, and eventually the case reached our court, and our court stopped that and said, right-wing party people get access to a city hall because we're living in a democracy. And an independent court will fall into your arm whether you block the right or the left. It will do it both ways. And there would be no one else to do that. No one else to do that. The town, however, and that's the more interesting point, did refuse to implement the ruling. And it did so officially, and it was backed up by the Minister of the Interior of that state. That's news in Germany. And you may now say, she's a German judge, she's maybe a little worried that somebody does not obey. But that's not my point. That's not my point. My point is that Karlsruhe and German constitutionalism are right now the country where everything seems to be still in order. And Karlsruhe is an extremely strong and influential court in the world. And many, many people look at that court and say, how do you do that exactly? That you accept it when you block the right wing and you block the left wing and you go this way and that way, but you defend the basics. Democracy, even in Europe, even in international expedition cases, even when refugees are exported, you block a government which does everything to export more refugees to get domestic politics at bay. People like that court generally. So now we have officials in Germany refusing to implement a judgment. To us, it's an indication of a crisis of the rule of law, and we take that extremely serious. And for the first time, I think, in the history of a court, we issued an official letter, also to the press and to the general public, and said and called on the state government to intervene and order that municipality to implement the ruling. And we still do not know whether this will really happen, but we're really worried that if it doesn't, the rule of law is under attack and democracy is in peril. And I thought a long time about using this example because I think, what are they going to think? Petty anecdotes from Germany? I urge you to reconsider. If you think these things simply happen, someone dislikes a ruling, there's criticism out there, get over that. I think you're wrong. I really do think you're wrong. In fact, the public refusal to implement a constitutional court ruling is an indication of an erosion of the rule of law, and I can give you way more indicators for that. And it is noteworthy that this happens even in a state in which constitutionalism is considered well and alive, and that it happens to Karlsruhe, which for many people is a super strong institution out there. It is a moment not to be taken lightly. And it is a moment, by the way, in which courts can issue a letter. But that's all we can do. If there are no amici curiae out there, better loss. We're out of the game. Arendt might have liked this point a lot. Courts are not alone. With her, we may understand law as a code not to be rejected, nor as the property of lawyers, nor certainly as the property of courts only. Rather, we should understand law and constitutional law in particular as a collective practice. But what exactly does that mean, a collective praxis? I think a collective praxis of courts doing their job, judging, issuing rulings, but amici curiae around it to critically follow these things, criticize them, but also support it even when they dislike the substantive result, if it's still the defense of the rule of democracy and the rule of law. So collective law is a collective practice when it is translated into daily reality, from, in German, Geltung to Wirkung, the vernacularization of human rights when they are applied, put into practice as ideas by individuals and collectives, public and private. But law is also put to practice in courts, in that law is brought to life to a court, and then a ruling issued by a court, which is all putting law into practice. My point is that courts are not the only ones doing this. There's a plethora of actors out there to bring the case, to argue the case, to comment on the case, to criticize the case in your next blog, etc., etc. This is all part of the collective action of constitutionalism. And you have several concepts out there to conceptualize this. Verfassungspatriotismus would be one. Constitutional patriotism. Interesting term, developed by Lord Dahrendorf and picked up by Habermas and made very prominent by Habermas. But constitutional patriotism, a belief in your home as a patriotism, well, for critical people, a challenge, but a very productive concept. If you don't like that, work with Peter Häberle's open community of interpreters of the Constitution. What did he do? He called on all of you to not leave constitutional law to the court and those super actors out there, but take it in your own hands and be part of the epistemic or interpretive community to make constitutionalism work. Or you may use Arendt. Despite her human rights skepticism and the lack of a systematic account of law in courts, she saw the need for limiting politics and suggested a constitutional court again as a constitutional convention in continuous session. That is an interesting image, a constitutional convention in continuous session. So if you go to a court, Karlsruhe or any other, it sometimes may feel as if the court puts the political debate on stage again that is so hard to have. A discursive attempt to pass legitimate rules. In a constitutional court hearing, if run properly and independently, you may have all parties present, empowered actors as well as disempowered actors, in a fairly structured hearing, and have many, many voices heard. Often way more voices heard in a court than in the general public and in parliament. Certainly, I would be the last to pretend that courts are ideal discursive spaces. That's not what I'm saying. But when you visit your court in your country, any of these constitutional mandated courts, or if you watch the Brazilian court that deliberates in public, or go to the three full-day hearings in Karlsruhe on measures to save the euro, or on the prohibition of a radical party, or on minimum life subsistency for refugees, or on law of access to your phone and computer for police and security forces. If you go to these hearings, what you will see is not some authoritarian closure, pressurous, legalists, obey order. What you will see is a discussion with sometimes way more people present than in regular controversies brought to you by your, smartphone? So what I'm saying is that courts as sites of constitutionalism and sides in some way of a collectivity, of a political collectivity, have the issues exposed, have opposing perspectives laid out, have national and international aspects of an issue considered, and this is a lot. So the dismissive stance towards law, judicial activism, they're overstepping their bounds, those judges, do they know what they're doing? Reevaluate these statements. Don't be overly snotty when it comes to remarks on court rulings and all those judges. If we understand, and if you understand constitutionalism as collective action, you may also then empower yourself to take this in your own hands. Don't leave it to others. There are many, many people who play these courts very well. They might not, be your allies. Do it as well. Take it in your hands. So note that there is no court ruling and no law out there, and no constitution, if nobody brings a case. So if people bring good cases and challenge the social equality in the world and challenge non-discrimination, etc., courts will react, and courts can be educated as well. So note that courts are not alone in interpreting the Constitution, but that they are important in doing so. So it is not only the parties that offer interpretation, it's political debates, it's domestic and international constitutional law, it's domestic and international discussions, etc. The Constitution serves as a codified external script based on an overlapping consensus by which abusive governments and abusive uses of the law are judged. And these days, also do not disregard that media coverage of rulings and other court activities is an important factor in these activities. So when I talk constitutionalism, and I want you to be amici of the court, I don't want you to put the courts on a pedestal. It's not, oh my God, the ECJ did this. Oh my God, Strasbourg came down with that ruling. It's a participatory stance towards the law, if you understand it with Arendt as collective action. So, last not least, the academy is important in that as well. Karlsruhe, for one, but I know that many, many colleagues in the world do this as well, takes note of each and every article published out there. By now, also blog posts. Each and every one. We read it all. We do not cite you, we do not tell you usually, but keep writing. Keep writing. If you want to do something to save democracy from the attacks and empower courts to go the right way and not the wrong way, and be independent institutions, unbiased, and fall into the arm of the majority, stop majorities, do work them, do educate them, do talk to them. Don't forget about them. Don't become a nihilist. That's a dangerous attitude. So, the courts. My argument is, don't forget about them, be sort of critically friendly to them, support them if they're in need, accept that you might not like a result of a ruling, but that you need to understand the function of the ruling for working democracy. So get what courts do. However, and this will be my last point, this is a little bit difficult. You will never really know how courts work. Courts are complicated institutions. Yeah, sure, everybody says that about their own things. But the point is that courts work based on the secrecy of deliberations, which protects us from political pressure and allows us to consider views we would not be able to expose in public. So secrecy of deliberations is a very, very important feature of judging. But it makes courts, it turns courts for you as researchers, as lawyers even, into a black box. You never really know. For courts, that's a good idea. I think for the independence of the judiciary, that's an existential idea. It's a conditio sine qua non. But still, it makes it a little difficult to call on you to, like the courts and engage with the courts, etc., etc. But then you don't know really the courts because they're this black box and you don't know what they're doing. Second, also, courts are institutions with a history and culture of their own, shaped by the people who serve, yes, but very path-dependent and very much situated in time and place and context. Individuals matter. Certainly, I do say that. Individual justices matter a lot, I tell you, but they only matter in the collective on the bench. Therefore, it seems totally inadequate, I think, to portray judges as heroes or, for that matter, heroines. It is totally inadequate to focus on single persons and to attribute to them that he or her, she, made that happen. It's nice. yeah, you know, we like applause. But it's totally inadequate and totally wrong. It also doesn't help courts at all, and neither helps the internal dynamics nor the court as an institution. Courts are important and they are strong because they're institutions and as long as they're seen as institutions. The minute you take them apart and start talking about him and her and this and that and right and all their biases, etc., you will weaken the court. It's interesting to understand it, but it's a risk to overemphasize the individuals in a court. In common law, it, however, happens quite regularly because of the way the judgments, the rulings are issued. And it is tempting, and that's, I think, the little remark on the side I want to make, it's tempting to engage in that civil religion to pray to the wise men and women up there, or that institution. Hannah Arendt actually was taken a little bit by a kind of admiration of the Supreme Court of the United States and her take on American politics, to pray to these wise men and women up there in their robes. That makes it even more easy and more resembling a religious ceremony. But it is also a very dangerous tendency because it dismisses democratic politics. Dirty politics out there, so many people, you know, and they're not that educated. And are they really smart? And then those 8 people in red robes. Isn't that wonderful? There is a temptation, a cultural temptation, which I think people should not fall for. It's also easier to study 8 than 637, right? But I just want to warn you, although I'm a little torn. I kind of like it if people, so don't portray judges as Hercules either, as was known in political philosophy. And don't underestimate that they're individuals. Robert Cover, for one, exposed the ability of judges to work with the law, even in settings which are heavily predetermined. And Hannah Arendt even saw Eichmann as the proponent of the normal, displaying the banality of evil, yet also she always insisted, that even bureaucrats like Eichmann always have space to move. So yes, there's space to move. Yes, there are people doing this. But no, don't overestimate the individual power and don't put them on pedestals out there. So I do agree that even in highly regulated positions, there's always a degree of freedom to be used, but the individual is nonetheless part of a collective and of an institution, and that will modify what she does. So courts have power. They are very specific institutions. You will never know the whole spiel, but do engage them and engage with them. However, and also, last remark, the power is limited. It rests in institutional design, but is modified in context. Arendt said, again, reacting to the District Court of Jerusalem's Eichmann judgment, quote, "The court could not overstep these limits without ending in complete failure. The court speaks with an authority whose very weight depends upon its limitation." So regarding courts, that final remark says they're important, they do wonderful things, criticize them, be on their side, engage them, but they only do so much. The rest is on you. Arendt stated that the great problem in politics, which I compare to the problem of squaring the circle in geometry, is how to find a form of government which puts the law above men. My argument is that constitutionalism is the answer, and that constitutionalism needs competent and independent courts for sure. But my argument is also, with Arendt, that this is never enough. These courts need amici curiae. So when Günter Frankenberg will today address the transformative promise of constitutional law, reconsider the skeptical attitude you might have had when you arrived here this morning. The times, I think, they are changing, and they need a more pragmatist stance towards judicial review, those judges overstepping their boundaries, the gouvernement de juge. Note the political developments in Hungary, Poland, or Turkey, to name those close in location and very close right now as EU member states, and even for the UK for a longer time as members of the European Council or the United Nations. In all these countries, as different as they are, there is an attack on democracy, which is an attack on open societies, on academic freedom of speech, on the media, on the right to assembly, on self-determination, everything critical people care for. The attack of democracy, however, starts with rough rhetorics and intimidation and threats and continues with corruption and street violence, etc., etc., etc. But the interesting point is that the first two institutions they get to is the media and the courts, and particularly the constitutional courts. Because if you undo a constitutional court or, recreate them to make them a lame duck, you're free. You can do things. You can do a lot of things, and if you watch these countries closely, it's scary how far you get without an independent court being able to stop anyone anymore. The media and the academy and the courts are, if they work properly, the counter-majoritarian forces in what is generally run by majority vote. If they go down, we do too. Therefore, there's a need of solidarity, certainly, with journalists in prison and with the researchers who lost their jobs and often also their home, and with the lawyers. My only point is there's also a need of solidarity with the courts. I know this is a bit more difficult. Courts are not your, marching buddy on the street. Courts are, these elitist people, often judges are parts of the elites of a society. Courts are not the outsider type you may easily identify with. You might not generally fall for them. That's all okay. Be critical. But in many contexts, judges are the only ones to stop majority-driven destruction and attack of the rule of law. Judges and courts may be far away from social movements, from student protest, from progressive politics, yes, but as institutional devices to safeguard democracy and constitutionalism, I think they're needed. So my only point is, with or without, engage in critical lawyering, because constitutionalism is a collective practice and it needs you. Thank you very much.